The City of Johannesburg will have to pay a property company 12.3 million rands and interest for loss of income and damages. It follows a precedent-setting lawsuit in the Gauteng division of the High Court, where the municipality was slammed for failing to provide alternative temporary shelter for 249 people who were occupying a building belonging to the company illegally, resulting in years of litigation. Legal analyst Elton Hart joins us now for more. Elton, a very good evening to you. Thanks very much for your time. I mean, this case has been going on for more than a dozen years. Why?
No, indeed, Vuyo, the case has been dragging on for a long time because there is a lot at stake here, and obviously the case also in itself, it's precedent setting in that now there is a case against which municipalities can be held accountable for their failures over the years to actually deal with what is actually a primary duty of a municipality. And I think this is a good thing. Maybe the rest of the municipalities around the country will also wake up.
Primary duty of the municipality to do what?
Yes, if you look at there is a act called, you know how politicians, they love these acronyms now, they call it SPOLUMA. Now it's the Spatial Planning Land Use Management Act that says municipalities has a duty to actually, in their region, do an audit to make sure what land is available to that municipality in that region, make sure that that land is sort of half developed in case a relocation needs to happen. It's already developed, and which means it must have water, sewage facilities, electricity. So in cases where the courts would say, okay, this is not suitable land, we relocate them, then they already know. But municipalities failed in their primary duty to make sure that they know what's happening in their region. And then they wait for courts to make orders, and then they come back with clumsy reports where they just say, in our region, there's no land available that's suitable for accommodation. And that's with a number of eviction cases that I've dealt over the years. That's the lame excuse municipalities come up, while the Act gives them a clear duty to say you need to make sure a land audit is done on a regular basis so you know exactly what is available for temporary emergency accommodation, and eventually for actually a relocation of people, say maybe from there's an informal settlement that is maybe on a waterlogged land that they can't stay there because floods will come and then their places will be flooded, that you can actually relocate them. And municipalities across the country has failed in that.
So in this instance, I mean, the City of Joburg is going to have to pay this company, property company, 12.3 million rands. But what are the broader implications of this ruling, just for municipalities generally, for neglecting to do their job under SPOLUMA?
Remember, we are now, when the court makes an order to say, okay, you need to provide temporary emergency accommodation, it means that the municipality now has a court order to comply with. If they do not comply, they're in contempt of court. So for starters, they can be held in contempt of court. But now it comes up when they don't provide this temporary emergency accommodation. The people that's in occupation of a property that the court said they have to vacate, if those people are evicted, then that people becomes homeless and destitute, going against their I think it's Section 26, going against the right not to be left homeless and destitute. On the other hand, you have to now balance the property owner's right, that can he now be paying the price for a municipality that failed to do their duty? No. And if that owner's rights is sort of infringed upon,